Hey everyone, welcome back to today's video. We got two sovereign citizens on deck, one out of Indiana and the other from Colorado, both bringing the usual courtroom chaos. Let's get into it.
Okay, this is cause number 4060022511 MF180. On the Zoom, who do we have?
Kurt Laker, Your Honor, for the plaintiff, Rocket Mortgage.
And then present in court, I'm sorry, sir. She told me you were hard of hearing. I need to speak up. Can you hear me okay, sir?
Yes.
Okay. Let me know, is that thing working better?
Yeah.
Okay, thank you. So this is Rocket Mortgage versus Joseph A. Novak, Maria G. Novak, in the state of Indiana through its Department of Revenue. We're here for a mortgage foreclosure. There's been some things filed, and we set this for hearing to try to sort things out. And sir, you filed some things contesting jurisdiction and service. Is that correct?
Yes.
Okay. What would you like to argue to the court?
Capacity. I don't know. Trial Rule 17A, the plaintiff must identify the real parties and interests.
And you feel they have not, done that?
Yes.
Okay. What else would you like to argue to the court?
Jurisdiction, which I guess is part of capacity, I guess.
Okay. And you're saying the court does not have jurisdiction? And why are you saying that?
Well, I'm asking what capacity. I don't know. I mean, like an officer, police officer, in their capacity as officer, then they can be in their capacity as their private capacity. I'm here in special appearance also.
Leave it up to sovereign citizens to put the extra special in special appearance.
I understand. And that's how you filed your paperwork. Because I think you filed a motion to stay these proceedings pending a clarification of jurisdiction. It was one of the papers that you filed.
Yes.
And so we set this for hearing so we can get some clarification of what you're asking this court to do. And that's what I'm trying to figure out. I want to know what the plaintiff is asking and then what you are asking. Then I can see what kind of a relief I can grant or not grant. So you wanted to stay these proceedings pending clarification of jurisdiction. Is that correct?
Yes.
Okay. And why do you think the court does not have jurisdiction?
Well, I want capacity defined. What capacity am I being compelled here in?
All right. Anything else that you want to argue to the court?
Nothing I can think of right now. I'm drawing a blank. I'm
Okay.
good at writing this stuff up. I just.
It's tough when you're under pressure here.
Yeah,
I understand.
sorry.
So what I'm going to do is I'm going to hear from the plaintiff and then I'm going to come back and hear from you in response to them. Okay. From the plaintiff standpoint, Mr. Novak is contesting jurisdiction, saying that we don't have jurisdiction over him or this case. Any response from the plaintiff?
Yes, Your Honor. As the court knows, jurisdiction is acquired by service of summons. The plaintiff did deliver, caused to be delivered, a summons to Mr. Novak by sheriff's service. A copy of the summons and complaint was dropped off at his residence. Same residence that he used that as a return address when he filed his responsive pleadings with the court. So I don't think there's any dispute that that's where Mr. Novak lives. The complaint and summons were dropped off by the sheriff and subsequently mailed. Both of those facts are reflected on the court's docket. That is the means under Trial Rule 4.1A3 by which we establish service and effectively bring Mr. Novak into court. We believe we've done that. And at this point, all we're asking the court to do is review the service, conclude that personal jurisdiction exists over Mr. Novak, and order him to file an answer, responsive pleading, or take whatever action he decides to take in response to the complaint.
Mr. Novak, I'm looking at the file and I'm seeing a summons that was mailed and left at 7334 North 200 East in LaPorte, Indiana, which is the property that's subject to this petition for foreclosure. And under the trial rules, that's what they're required to do to obtain notice and jurisdiction.
And just like that, his jurisdiction argument flies straight out the window, taking whatever was left of his reasoning with it. Now that the procedural issues are out of the way, buckle up, because what comes next is some of the most mind-numbing nonsense you'll ever hear someone say in a courtroom.
What other clarification are you seeking?
Residence. Well, he says, I'm a resident. What makes me a resident? I don't know all these. When I look up definitions of things, and like like for instance, traffic, Trial 9. I mean, you look up, there's definitions of words, and you go to another title, and there's a bunch of other definitions. The definition keeps changing. My view of the word residence, it's Latin. Res is the object of a trust. Ident is the same as identical, identify. Resident, to me, I think that means you're saying you're the object of a trust. And I know all these words have legal terminology. I don't know what they, maybe my definition of that is wrong.
That's absolutely incorrect. Something you might realize if you stop relying on oversimplified, fill-in-the-blank legal guides. A resident is simply someone who lives in a particular place for an extended period of time. It's not some mystical loophole term you can redefine to suit your argument.
But I've filed into the county recorder a notice that I'm not a resident, a domicile, a situs. I've looked up all these words, and they have legal terminology. They have different. What am I? When you're saying I'm a resident, how do you identify me as a resident? What makes me a resident?
Okay.
And the service says, the sheriff's service, which I don't have it with me, but it said just left at last address. It doesn't say where it was left, who it was left with, when it was left, how it was left. And at the top it says the officer's instructions, it's circled read. And there's one that says left, and left isn't circled. I don't know what that means. Was he supposed to show up and read it to me?
Any response, counsel?
Your Honor, just in regards to the leaving of the summons, the docket is clear, what occurred. The summons was left along with the complaint. It was mailed. I don't think there's any dispute that Mr. Novak actually received it. Receipt of the summons and complaint is what caused him to file these pleadings. So it's those are the hurdles. Those are the jurisdictional hurdles that we're required to hit, and we've hit them. He's here now. He's filed an appearance. He's aware that we filed a claim against him. I think the court pretty clearly has personal jurisdiction regarding some of the other sort of esoteric arguments that Mr. Novak is making about the meaning of various words. I guess I would just point out that the trial rule 4 speaks of leaving it as his place of abode, residency, domicile, these other esoteric concepts are just not baked into the trial rules for purposes of service of summons. Mr. Novak is a real person. He's sitting in front of us. He lives in a place. We delivered the summons to that place, and the sheriff mailed a copy of it to that same place. So I'm not sure what else is to be expected of my client to properly put him on notice of the claims that have been made against him. He has everything he needs to put forth whatever defense that he chooses to make, and we would ask that the court order him to do that at this point.
All right, Mr. Novak, I understand what you're saying about resident, and I understand what you're saying about capacity. Any other arguments you want to make to the court?
He said real person. Is that natural person? Because when I looked up the definition of person in trial in Title IX, there's 14 entities, and none of them say man or woman. It's a corporation, company, association, firm, society, blah, 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 blah. Nothing says man or woman.
Well, Title IX of the Indiana Code deals with motor vehicle laws, and you're in an eviction case. So right out of the gate, you're digging through the wrong section of the law entirely.
So can I get a definition on what real person he means? And also property. When I look up property in Black's Law Dictionary 11th edition, page 1470, it says property is a collection of rights in something of value such as land. Property is not the land. Property is the rights in the land. It's equitable interest. It's your right to enjoy, own, transfer, and dispose. So,
And are you not claiming any right in 7334 North 200 East in LaPorte, Indiana?
any right in that?
Any ownership of that? Or use of?
Sorry.
I'm not trying to make you nervous. I'm just trying to understand your argument.
I've got bad allergies.
Okay.
And it's terrible.
You're probably allergic to common sense, and considering how little of it you seem to carry around each day, it's clearly not doing your health or your living situation any favors.
No, I have patented land there.
Okay.
And I claim the patented land. I literally have the land patent signed by Martin Van Buren in 1837, and it's certified from the Bureau of Land Management, Government Land Office, the Department of the Interior. It's patented land. It's not property. And if I own land, do I need to pay for rights in it?
Okay. And you understand that the mortgage company that's the plaintiff is claiming an interest in that land because of a mortgage document?
Yes, and I really don't want to get into. From what I understand, if I get into merits, then that puts me in general insurance. I'm not even an amateur litigant. I'm just Joe Blow down the street. That's all.
I understand.
And I'm being careful. I'm not trying to resist anything. And
I understand you're hearing here in a limited purpose only. So let me do this. I think I understand your arguments. I'm going to go back and I'm going to reread what you have filed and all your pleadings. And counsel, I'll read what you have filed in your pleadings, and then I'll issue a ruling as to what the clarification Mr. Novak is requesting. That ruling may be one, that there has been no proof of service, or it may be two, there has been proof of service, and now Mr. Novak, you have X amount of time to respond, and then you can file any other defenses and responses that you have at that time. Okay.
And I have recordings with the county recorder about the land and about me personally.
And you'll be able to file all of that with the court to prove what your interest is. I've been doing this a long time. I've only seen a couple of actual patents, land patents come through. But I'm happy to entertain whatever that proof that you have. But let me dig into the actual capacity and the notice, and then I'll get a ruling out clarifying what that is. Okay.
Okay.
All right.
I'm pretty sure I can predict the ruling with perfect accuracy. Yes, a land patent is strong evidence of title. It shows that the government originally owned the land and transferred it to a private individual. But, and this is the part you're ignoring, contract law still applies. When you signed that mortgage, you gave the bank a security interest in the property. You can't wave around a 19th century land patent to erase a 21st century mortgage agreement you voluntarily signed. If you don't pay the loan, the bank's lien remains attached to the property, and foreclosure is still on the table. That wraps up the first hearing. The judge will issue a written ruling to the parties, and we'll see how things unfold at the eviction hearing. Now we move on to our next sovereign citizen, who believes the defendant is just a stack of paperwork rather than the actual person who got behind the wheel and drove under the influence.
Paul Strumpler. Good afternoon, sir.
I'm here for the matter at hand.
Have a seat, please. And did I mispronounce your last name? I said Strupler. I don't know. Is that how you pronounce it?
You can pronounce it how you like. Yeah.
Okay. I'm glad to pronounce it however you do.
Yep. With the family of Strumpler. And I'm here on behalf of the named defendant.
Well, are you Paul Strumpler?
My name is Paul Robert of the family of Strumpler.
Okay.
P, lowercase a.
So you're the defendant then?
No.
Okay, well then you can have a seat because I'm looking for the defendant.
Defendant is right here.
Okay. You're either Paul Robert Strumpler or you're not. So if you are, please have a seat. If you're not, you may have a seat in the benches. Otherwise, you may sit at the table if you're the defendant.
Please show you that the defendant is right here.
No. You may have a seat in that chair and then I'll call your case.
Okay.
Honestly, this is exactly how judges should handle this kind of nonsense. If you don't want to acknowledge that you're a defendant, fine. Go sit in the gallery as an observer and watch while the judge signs a bench warrant for the person you're pretending not to be.
You don't want to, are you not the defendant?
I'd like to retain my rights.
You can retain your rights,
Thank you.
but are you the defendant, Paul Robert Strumpler?
As I said, I am here on behalf of the defendant under special limited appearance.
Can you make sure the microphone is tipped towards your mouth there? Thank you.
I'm here under special limited appearance on behalf of the named defendant.
Okay, I don't know what that means. I just need to know whether you are Paul Robert Strumpler.
You can refer to me as Paul, yes.
Okay. I'm going to take it that you are Paul Robert Strumpler, the defendant in this case. I'm going to call the case now. We're on the record in 25T422, People versus Paul Robert Strumpler. Mr. Strumpler is present in court in person, pro se today. Mr. Garrett is here for the district attorney's office. We're scheduled today for appearance of counsel. Mr. Strumpler, last time you were in court, I believe you said that you were considering getting an attorney. Have you obtained an attorney?
I was wondering if you had a chance to look over any of the exhibits that were filed recently into the case.
I see that you filed a number of things yesterday,
Mm-hmm.
and I have not looked at them, but based upon their titles, they are meaningless in this case.
Well, the reason I brought that up is because some of those documents pertain to the attorney issue.
Okay, which one?
You could go to the one titled General POA, and I can give you the exhibit number here in a moment.
Okay.
That would be exhibit 5.
All right, I'm looking at what is labeled exhibit 5. Okay, I don't understand what this is. Well, how does this have to do with you getting an attorney?
Well, I am a attorney in fact for Paul Robert
You're an
Strumpler.
attorney?
Correct, an attorney in fact.
Okay. What is your bar license number?
Attorney in fact is not part of the bar.
Oh, so you're not actually a licensed attorney. An attorney, in fact, is basically someone operating under a power of attorney. And that doesn't authorize you to represent someone in court. That requires a licensed attorney at law. You might want to hire a real lawyer instead of pretending you're starring in your own courtroom drama.
Okay. So then you're not a licensed attorney. so you cannot represent anybody as an attorney. But as I understand it, you're the defendant. So what do you want to do in this case, Mr. Strumpler? Do you want to plead guilty or not guilty? Do you want to get an attorney? Do you want to talk to the prosecutor? What do you want to do? Those are some of your options.
I'm wondering if you would please go through the documents pertaining to jurisdiction and the attorney issue so that we can, further have this conversation. If that's going to take some more time, that's fine. I was under the impression that I was here today just to explain whether I would be here pro se or not. I prefer to be here sui juris pro per, and if you prefer pro se, we can go with that. For the record, I prefer sui juris pro per, and it would be nice to know if you have gone through these documents in full so that the information is in both our minds.
So let me explain something to you. You can file documents with the court, but they don't mean anything unless you're asking me to do something. If you're asking me to do something, you would file a motion to whatever. I don't know what you might want to
Sure.
ask me to do.
Sure.
Just filing, for example, all these documents, ecclesiastical deed poll, all these exhibits, notice, last will, none of this is it's all meaningless. It has no meaning in this case or effect. Mr. Garrett?
And Your Honor, because I saw the exhibits that were submitted to our office, and then as well as kind of what we've seen today. I know it's kind of rare for the prosecution to express concerns in competency, but at this time, I think I would be asking. I do have concerns for competency, and I would be asking the court to order an out of custody comp eval.
Okay. I think I'm going to want you to do that in writing.
Okay.
I want to have that documented. Okay. So, Mr. Strumpler, at this point in your case, all we're talking about is whether you want to have an attorney or not, and whether you want to plead guilty or not guilty, and set it for trial. So that's what we're trying to decide right now.
I'm aware. I would like to know who's bringing the claims and to see the claim before I can plead to any charges.
So it's the district attorney, the elected district attorney on
Right.
behalf of the people of the state of Colorado. They are the ones that are prosecuting you.
Right.
So they're the ones bringing the charges.
May I have a moment to speak further? Because I believe there's some presumptions that are being presumed here that I would like to challenge.
Like what exactly? You're trying to challenge a presumption that you're a natural, living person? Because from the way you're arguing, it sounds less like a legal theory and more like you've donated your common sense somewhere along the way.
For the record?
No. You may tell me if you want to represent yourself or if you want to get an attorney. That's one question I have. And the other question you may answer is whether you want to plead guilty or not guilty. Those are the two questions I have for you today. Those are the questions you may answer.
I'm here on behalf of myself. I've given you, again, I don't have the charges in front of me, so if you can provide them to me, that would be great. But
So the only thing that I have in your case, sir, is I have the affidavit in support of warrantless arrest.
right?
And I have the complaint with the charges, so I'm printing those out for you.
Great. Thank you.
You're welcome. So what do you want to do with regard to an attorney? Do you want to represent yourself, hire your own attorney, or apply for the public defender to represent
I'll
you?
represent myself.
Represent yourself, okay.
Sure.
And then do you want to plead not guilty and set the case for trial today? Or do you want to enter into negotiations with the district attorney?
What would the negotiations look like?
Well, typically, the district attorney would make you an offer.
Mhm.
They would say, if you plead guilty to this charge, these charges will be dismissed, and we'll agree to make these concessions for sentencing. So now I don't have control over them. They are their own office. They don't have to talk to you. They don't have to make you an offer, but they usually will if you want.
Right. I would like to ask about the administration of the estate and how we can just take care of it, possibly more so in the private. Is there any reason we can't move this into the private?
This is a criminal case, so you are facing possible jail time. And this is not a private matter, it's a public criminal matter.
Okay.
Did we give him those documents? You can go ahead and do that. Thank you. Now, I think there's a blood test in this case. Is that right, Mr. Garrett?
That's correct, Your Honor.
So, Mr. Strumpler, I'll come back to you. Mr. Garrett, how would you like to proceed on this case? Would you like to set this for trial? Would you like to just have a status conference for the blood test results? What's your perspective?
So the charge date was November 12th, so we're not even a month out. And based off how long it's been taking to get the blood results, I would just ask for a status conference with the blood.
Okay. And if Mr. Strumpler is wanting to talk with you about his case, are you willing to do that?
Yes, Your Honor.
If you're going to argue with a sovereign citizen, you might want to keep your metaphorical glass windows covered, because they have a talent for throwing legal bricks at anything that looks remotely logical.
So, Mr. Strumpler, then what I'm planning to do is set this for what's called a status conference in January, or maybe even February, because there's blood test results that the district attorney would like to get before they decide what they want to do. But let me explain a right that you have. You have a right to be brought to trial within 6 months, okay? So in order to get that's called a speedy trial clock.
Right.
In order to get that speedy trial clock running, you have to plead not guilty. So you do have that right to plead not guilty and get the speedy trial clock running if you want to, or you can wait to do that and talk with the DA if you want to.
Wait to get the speedy trial clock running?
Yeah, the 6-month speedy trial clock doesn't start running until you say not guilty. Then it starts.
Okay.
So you can do that today, or you can wait until the next time we come to court. And between now and then, if you want to, you may try to talk to Mr. Garrett about your case. You don't have to, but you may.
And the other date you said was February?
Oh, I was thinking I'd probably set this out. Do you want to go into February, Mr. Garrett? Like February 4 or 11?
February 11th works.
February 11 is 10 weeks. So that's what Mr. Garrett is proposing.
For us to come back and speak some more?
Yeah, to see if there's any change in your position, his position, or if we have the blood test results. We probably won't by then, but it's a check-in date.
Okay.
And if between now and then, if you change your mind and you want to get an attorney, you go ahead and do that.
Okay. And then at that time, I would then have the chance to plead not guilty
If
and
you
start
want
the
to.
clock.
Yes.
All right. That would be ideal, I suppose, to go ahead and shoot for that date if you'd like, and then we
Okay.
can have a chance to convene in the meantime.
Do you
And on
prefer,
that date.
do you prefer coming back at 11 a.m. or 3 p.m.?
Let's do 3.
3 p.m.
Yep.
on February 11. We'll be scheduled for a status conference. Mr. Strumpler, let me ask you a couple of questions. Do you understand my role as judge?
From what I'm aware of, you're here to fairly run the court proceedings, and just to be a moderator, basically. This is, in a sense, the one who I'm opposed with in this hearing.
Okay. And for the record, you're pointing over to Mr. Garrett, that side, that table,
For the record,
prosecution.
yes,
Yep.
yes.
Okay, so they're prosecuting you.
Yes.
Okay. And do you understand, I think we talked about this, but do you understand the possible penalties for these charges, or do you want me to go over that again with you?
I'm aware of them.
Okay. Do you
Yeah.
know the maximum jail sentence for driving under the influence?
Was it up to a year?
Yep, that's
Yeah.
right.
It's unbelievable how casually sovereign citizens toss away an entire year of their lives, all because they think the law somehow doesn't apply to them, when everyone else knows it does. If you ever find yourself in a situation like this, take your freedom seriously and get a qualified attorney.
Okay. And do you understand that you have the right to plead not guilty and have a trial to determine if you're guilty?
Yes.
So at the trial, that could either be to a judge or a jury. And do you understand that it's the prosecution's burden to prove you guilty beyond a reasonable doubt at a trial? Do you understand that?
Yes.
Okay.
Okay.
And do you understand you have the right to remain silent at a trial?
Yes.
But you also could testify. Do you understand that?
Yes.
Okay. Mr. Garrett, it may be obvious. I'm trying to probe a little bit into competency. Any other questions that you can think of that you'd recommend I ask regarding competency?
Not at this time, Your Honor.
Okay. All right, Mr. Strumpler, do you have any other questions for me today?
I suppose I would just like to know if I can get the best contact information from you. Thank you.
All right. Yep, Mr. Garrett.
That way
So the
we can-
DA's office is in this courthouse downstairs on the basement garden level back in that corner.
Mhm.
And so you can go talk to them. Have you received all the discovery in your case yet? All the police reports, body worn
Haven't
camera?
received nothing.
Okay, so that's your responsibility to go get that,
Sure.
but it's available for you.
Okay.
So you can go downstairs and obtain that information, okay?
Okay.
And I would recommend you do that.
Yep.
Okay. Any other questions?
The particulars for this next date will be coming. How do I receive that information in writing?
I don't know exactly what you mean, but the
That's-
February 11 date,
Yeah.
we're calling it a status conference. We're going to
Okay.
check on the blood test results. I'm going to check with you to see if you've changed your mind about an attorney. I'm going to check with Mr. Garrett to see if anything has changed about the case. And it's really just a check-in. And you may plead not guilty that day if you want to. That's your decision.
All right.
That makes sense?
Yep.
Okay. And again, just so you know, you can file things with the court, but they don't have any effect unless you file a motion asking me to do something based upon some legal argument.
Sure.
Okay.
And yeah, that is the reason I put those in there so that I could call upon them with motions.
Okay.
Between now and then, can I file motions?
You're always welcome to file motions. I will tell you, typically motions are handled at what's called a motions hearing,
Mm-hmm.
and that's normally after a person pleads not guilty,
Mm-hmm.
but it's not required to go that way. You can file a motion anytime you want.
Sure. And I can do that by mail.
Yes?
Yeah.
But your motion does need to have a basis, a good faith, ethical, legal basis in both fact and law.
Absolutely. Yeah.
Okay?
Sure. Thank you. I'd like to, do everything as honorably and equitably as I'm able to, and hope we can come to a good closure of this case. Thank
Okay.
you.
Thank you.
All right, that wraps up his hearing and today's video. As you probably heard, his next hearing is scheduled for Wednesday, and I'll be watching closely to make sure he doesn't do anything ridiculous. If he does, you'll see it right here on this channel. If you liked the video, hit the like button. If not, hit dislike. Either way, leave a comment below and make sure you're subscribed with notifications on so you don't miss any of my content.